Good.
My lords.
Item number 2.
Pertains to cancellation act.
Item number 3.
Cancellation.
Item number 4.
May I provide you? My lords. Cancel number RC.
Where is your counterpart, sir? Somebody must hand over something.
RC cancel.
Just sitting remotely will not do, sir. Yes.
Item number 5.
Cancellation of us.
Item number 5.
Yes.
Item number 6.
RC cancel. Seven.
Item number 7.
Yes.
Item 8. Item number 9. Item number 10.
Cancellation.
Item number 11.
This matter relates to cancellation. 12 is also same. 12 is also same.
Item 13.
13, 14 year lordship 73 4B, 15 year lordship 73 4B along with 84.
Yes, why are you in hurry? 13 is called.
13. 23. 4.
73.
Item number 14.
73 4B,
14.
73 4B,
Item 15.
73 4B along with section 84 2. Your lordship, that review, commissioner's review is related to that.
Yes, go. Yes.
Authorization for the search. Section 67, the authorization of the search conducted under Section 67(2) of the OVAC Act and the proceeding initiated thereafter under Section 130.
Yes.
The Lordship will kindly turn to page 20, Annexure 1, which is a copy of the authorization in INS 01. And if the Lordship could see the Lord at the left-hand bottom, it bears no seal. And if your Lordship would, it bears no seal, my lords.
I know.
If the Lordship would turn over the page, the Joint Commissioner's signature is also missing, my lord, at top right-hand column. So in my humble submission, my lord, that this is a statutory form of authorization which has to be sealed and signed by the Joint Commissioner. There's no other officer lower to the rank of the Joint Commissioner can authorize a search of the premises. So in my humble submission, Lord, the very initiation of the authorization for search is defective and therefore it vitiates the entire process. In addition to that, Lord, there is an allegation that there was an excess of stock. So my humble contention, Lord, is there's either an excess or a shortage, Lord. It means there's a deemed sale or supply of goods or services. So here, my lords, the procedure to be adopted as per Section 35, subsection 6, the deemed amount of materials were not reflected in the books of accounts and have been clandestinely either removed or clandestinely not mentioned in the search report. So the procedure, my lord, is either a proceeding under 73 or 74, but not a fine in lieu of confiscation under Section 130. So these are the two points for which this petition has been filed. So as the second point is concerned, the Allahabad High Court has already held that in such a situation where there's an excess or a shortage of stock, 130 is not the proceeding, but they should resort to a proceeding under either 73 or 74. Because these are out of account sales. So since 37...
I understand.
And
this...
Your lordship, so far as the first issue is concerned, so far as that signature of the authorization, your lordship, this authorization, your lordship, now everything has to be generated from the portal, your lordship. So for that reason, your lordship, may kindly turn to that page 20. The reference number, the case ID, the Joint Commissioner himself has generated, because once the deemed, your lordship, the number has been generated on his portal. So it cannot be generated by anybody, your lordship, only Joint Commissioner with his reference number, your lordship, at the top of the reference number, case ID, everything has been generated, and subsequently this has been transferred to the search unit, your lordship. So far as the signature, your lordship, at that time, there were not digital signatures. Subsequently, recently, your lordship, that portal has been developed, and in place of signature, the digital signature has been inserted. At that point of time, there was no digital signature. Only the case number generated, reference number and case number has been generated from the portal, from the Joint Commissioner's portal. So that is a valid document. Also, record is with me. That is a valid document. So far as the other issue as regards to 130, your lordship, that I will file a detailed counter, because your lordship, if at all, your lordship, to some extent there are some other judgments are also. Why, your lordship, I am submitting this? Because if this will be held as per section 35(6), only 73, 74 will be done. Then your lordship, section 122 and 130 will be redundant. Because the same provision, your lordship, for a moment, may kindly turn to section 122 and section 130. Your lordship, both the aspects are there. So far as the excessive stock, suppression of stock, your lordship has already decided in case of Biraj State. In suppression of stock, confiscation can be made. In excess, if at success, suppression of stock, 130 is maintainable. Your lordship has decided pursuant to the judgment of Honorable Supreme Court. Then your lordship, excessive stock is automatic, that can be confiscated, and 130, 122. Your lordship, for a moment, may kindly turn to the provision of section 122 and 130. Your lordship, my Lawrence, see 122.
Yes.
Your lordship, 122, your lordship, may kindly direct turn to section surplus Roman 1, supplies any goods or service or though without issue of any invoice, or issue an incorrect or false invoice with regard to any such supply. Now, your lordship, may kindly turn to the last 15, Roman 15, your lordship. Suppresses his turnover, leading to evasion of tax under this act. Your lordship, next, fails to keep, maintain, retain books of accounts and other documents with the provisions of the act or rules, your lordship. Your lordship, then 1 plus mainly 18 may kindly come to supplies, transport or stores. Your lordship, excessive stock is the stores. Any goods which has reason to believe are liable to confiscation under this act. So, your lordship, here in the instant case, your lordship, the stock what has been disclosed in the return, as well as your lordship, 94,44,336, whereas the actual stock at the time of inventory, the actual stock is 2,37,56,056. Your lordship, page 29 of the writ petition, the annexure 6. Your lordship, the excessive stock which has not been disclosed in the books of accounts, your lordship. Now, your lordship, may kindly turn to section 130.
I'm looking at it.
Your lordship, section 130 also supplies or receives any goods in contravention of any provisions of the act or rules made thereunder with intent to evade payment of tax. Your lordship, there is a clear-cut intention to evade the payment of tax, your lordship, and do not account for any goods on which is liable to pay tax under this act, supplies any goods and contravenes any provision. So, your lordship, 122 and 130 both are clear. If at all for a moment it is accepted that the Article 35(6), 70, 73, 74 should have been done, then these two provisions will be, your lordship, redundant, your lordship. So, your lordship, one of the option, one of the assessing or adjudicating authority has chosen one of the option, your lordship, and he has done this. If repeated again 73, 74 on the same issue, then matter is something else, your lordship.
Show me, sir, other judgments.
This is confirmed by the Honorable Supreme Court, which says, my lord, they have gone to the Supreme Court against this. We are not inclined to interfere with the impugned judgment or order passed by the High Court. The special leave petition is accordingly dismissed. We, however, clarify that the impugned judgment order and the dismissal of this special leave petition will not come in the way of the petitioner in taking recourse to appropriate remedies in accordance with law. And so far, my learned friend says that the lordship is, we are astonished to see that they have taken the average profit. If the lordship would kindly turn to page 29, they apply a formula unknown to the VAT Act. The GST Act. Your lordship may see the second column. They adopt my profit margin to, your lordship may see book stock as per profit and loss account, stock determined at 23-24 at page 29 and lordship. By taking average sale as no document is available. So they take my average sale, and if the lordship would turn to page 31, they adopt a formula, and then they say that there's an excess of stock. There's no verification. My stocks are available. In case, my lord, assuming the worst against me, my lord, that if I do not have any documents, the stocks are there very much before them, my lord. They could have taken an inventory of the stock, my lord. And without taking an inventory of the stock, my lords, my humble contention, my lord, they can't resort to confiscation. Because 130 speaks of confiscation, and any penalty here is in lieu of that confiscation. And that confiscation can only be done, my lords, for goods available. And for that, they have to ascertain.
Right.
They can't, my lord, take my profit margin. And if the lord would kindly turn to page 30 at the bottom, they adopt a formula, my lords. And that formula, they see, my lord, the unnumbered paragraph, my lords, after the column, my lords.
Reason given, Mr.
No?
It is a reason given why inventory could not be
No, the reason, my lord, my humble contention is
page 31.
page 31. No? Further, in the financial year 23-24, you have neither filed GST or 3B, nor maintained any stock of inward or outward supply of goods. You have not maintained stock register. So these are, my lord, indications of section 35 laws. These non-maintenance of stock accounts, these non-maintenance of sale accounts, the lordship would kindly turn to page 35. They are being, my lord, provided for in section 35. So if this is my allegation, I bow down to your lordship, sir, my lord, for pointing out. If the lordship will kindly turn to page section 35. No?
This is your
Every registered dealer shall keep and maintain at his principal place of business
Is it?
as mentioned in the certificate of registration.
Then send him to appeal.
In Sahiti, very lucidly, Andhra Pradesh High Court said with regard to that signature. In Sahiti, that aspect, the lordships have said that once it is uploaded, this is a digital mode of signing.
This is given.
No, first round which you have to. So that part is already confirmed there.
My humble contention.
Then with this, with regard to this one, I think you have to approach the appellate authority.
Lordship may see the basis. They take out, they take out the
Stock account you have not maintained, then
If
you have to adopt some method to find out.
No, there are two
possible
aspects.
stock shortage.
The total non-maintenance of an stock registers, or there is some discrepancies which is found in the stock register.
He's saying, there's total non-maintenance of stock register. So that is why I say, 35, 1 million is attractive. So if it is 35 millions, your lordship may see, if it is 35.
Go for an appeal. Go for an appeal. Do it, exhaust your remedy. We have taken that's a uniform view here. Once you have, you go there. They are their last court of facts. They will definitely look into it.
No, here, annexure 1 goes to the very jurisdiction. My humble contention on this particular authorization.
Then we will decide this on that ground and will not held that the rate is maintainable. Because these are all electronically generated these things, and they have those signatures there put.
They have to have a facsimile signature. If it is electronically generated, there has to be a facsimile signature.
Andhra Pradesh High Court referred to. Rule 23. 23, 143, forward. We are not gone through.
Sahiti Lord, with great respect, Sahiti Lord is Sahiti is still, it's,
You have, that is cited,
that is
Where is
still
that?
pending, no, that's still pending with the Honorable Supreme Court.
no, Sahiti is not, no.
Sahiti is from.
Sahiti.
22 is a cancellation of the
We'll
registration.
give the number of the SLP number will be given to you now.
2017 we
Sahiti referred to.
Subsequently, digital signature is demanded.
The first part was digital signature.
Again, you got it. That reference number and SID.
SLP number 1429 of 2026.
Where, what is the rule referred to by Andhra Pradesh High Court? See, first part.
Yes.
So the other part is multiple tax periods that they have admitted. That they have said that following some other case, they have decided this has been. But first part they have decided very lucidly.
It has to be on the 35.
35 does not stand.
35 and occupant C minus 35.
This is not standalone. Even 35 has the reference of 73, 74.
Right. So that the proceeding of 35 6 says that for any of these violations, if a occupant kindly will permit me to place 35
And,
1.
under which circumstances you feel this part will come?
Because 130 speaks of confiscation. 130, if you also kindly see 130 is the provision for confiscation. Confiscation
go
of
for an-
advance and levy of penalty.
go for an appeal. Take
I have a difficulty then.
what if
Suppose I have to await national highways fees. I have to await national highways fees.
means?
The loss.
Oh, you have already outer limit is crossed. No,
No, I'm sorry.
1/3/2025, your name, your.
I'm sorry. The writ petition has been filed in time.
Writ petition.
I'm sorry, I stand corrected. Still, the Lord's I bought on, but still, your Lord would appreciate that 30.
credit,
And 30.
maintenance of the record and all
30.
everything.
And the allegation your Lordship also has already.
Yes, yes.
There's no stop.
Go there. Maintain it. Yes. Next,
Keep all questions open.
without a show cause notice.
Only DRC 01 at page 21 and also. Only DRC 01 has been issued, which is something.
Yes, what do you say?
There's no show good.
Yes.
Years enclosed.
Your Lordship,
By page 20,
yes, Your Lordship.
page 21, years enclosed, annexure 1.
Yes, yes.
The DRC
Summary of
0,
show cause
the
notice.
demand-
It has been clearly written, Your Lordship. It is a summary of show cause notice. If Your Lordship kindly have rule 142 under which it has been issued. If I may read, Your Lordship.
These are the annexure also, the 24 page 24.
You have received against those, you have failed to disclose the payment.
Yes, Your Lordship.
Yes.
It is a basic summary of show cause notice which has to be issued after the show cause notice.
Yes, detailed notice is given, DRC 1. Page 24.
Your Lordship, DRC one is the summary of the show cause notice which has to be.
No,
Notice is issued.
no.
If your Lordship would kindly have Rule 142, your Lordship, under which this has been issued.
Rule?
Rule 142, your Lordship, of the GST rules.
Yes.
142, notice and order for demand of amounts payable under the Act. The proper officer shall serve along with the notice issued under section 52, 73 or 74, 76 or 122 or section 123,
A
124.
summary there in a electronic form GST DRC
One, which is
So-
summary. This
So-
is DRC 01 basically is a summary of the show cause notice, but no show cause notice has been
Oh,
issued.
nothing.
Page 24. It's 24.
Oh, sorry.
connected to
I have seen. Sorry.
Your Lordship.
And
Sorry.
more so, your Lordship, Annexure
Okay.
2.
Would you like to go for an appeal or not?
Your
That's
Lordship,
it.
if
Would you go for an appeal or we dismiss
If
here?
I may submit, your Lordship, there is a
Will you
similar.
go for an appeal or we dismiss deciding this point?
I will go for an appeal, your Lordship. I
Go
will
there.
just draw your attention, Lordship,
Just-
was judgment of the Guwahati High Court, your Lordship.
We are
Your Lordship,
bound by our own judgment.
Here the appeal,
Why will travel so much?
They have also illegally deducted demand
No.
amounts, your Lordship.
Whatever.
Electronic intelligence.
Go for an appeal.
your Lordship, against that adjudication order. he will not-
Already. Go for an appeal
Against the rectification order, he can go to appeal.
or
The
whatever.
rectification order has been passed.
Yes, let them go for an appeal.
7th March 2026.
Yes.
Page
Page, your Lordship, 48.
40.
48. That starts
starts
at
at
Annexure 8,
46.
page 46 starts. This
Annexure 8.
actually, this is the error committed by the
Within the
officers.
limitation.
This is the error committed by
Within
the.
the limitation,
Your Lordship,
Yes,
while
rectification, no limitation. That
you are there.
Your Lordship, it was kept pending for 1.5 years, and while this was pending,
Take that all plea. Take that plea.
Then your Lordship, if my friend's government will be accepted, then your Lordship may quash that rectification and he is remediless.
Item 14.
Here is an admitted tax liability of petitioner. Admitted tax liability, my petitioner is ready to pay the entire tax dues. He has already paid first 55 lakhs out of 2.49 lakhs. But my bank account has been attached under annexure 7 and 9.
Well, obviously, when you have not paid the full amount, then what they will do?
No, but the issue is here is that the DRC 7 has not been issued, and against the show cause, they have directly jumped to the recovery process. That is my difficulty. So I pray, for some time in the granted within 4 months. Wait.
Not required to be issued. This is a new provision. Rule 88C, your Lordship may kindly look into. This is also first time I came across. Rule 88C. I'm also on the same impression that how without order the attachment has been done.
Rule 88C, which they are referring, there also they have not followed the procedure.
Like,
They have not
I am all the with all the instruction, all the documents.
They have not issued, my lord.
Please. These are the admitted tax liability.
Admit act.
Here, let's see, where the tax payable by a registered person in accordance with the statement of outward supply furnished by him in Form GSTR 1 or using the invoice furnishing facility in respect of the tax period exceed the amount tax payable by such person in accordance with the tax for the period furnished by him in GSTR 3B. Your Lordship may kindly turn to then A. Your Lordship, sorry. But the said registered person shall be intimated of such difference in Part A of Form GSTR DRC 01B electronically on the common portal. The copy of such intimations are also sent to the email address provided at the time of registration as amended form, time to time highlighting the said difference and directing him to pay the difference. F1B is there. I haven't chosen. Explain the aforesaid difference so and so within a period of 7 days. The registered person shall, upon receipt of the intimation referred to in Subsidy, either pay the form of differential tax liability in specified Part A DRC 01B fully after DRC 01, furnish a reply electronically incorporating the reason so and so, where any amount specified in the intimation referred to in Subsidy 1 remains unpaid within the period specified in the Subsidy, and where no explanation or reason be furnished by the registered person with explanation, a reason furnished by the person is not found to be acceptable by the person, by the proper officer, the said amount shall be recoverable in accordance with section 79. Your Lordship may kindly look into the date chart. I have prepared a date chart, Your Lordship. Here, 3 proceeding, Your Lordship, has been initiated. One proceeding under section 74(8) from April to August, that is pending. That is pending. On that we have not touched. For May, for August, for November, 3 proceedings has been initiated against that bill.
What you have done?
Your Lordship, we have issued one bill. Your Lordship may kindly look into.
What you have done?
Your Lordship, Your Lordship may
What
kindly
you have done? What you have done?
turn to page 9.
I am asking you what you have done.
We have issued DRC 01B
Mhm.
for page 9
For what?
for payment of that amount, differential amount. He has not paid.
Correct. I understand.
Then we have issued DRC 01D
Yeah, what for?
for recovery
Recovery from where?
from Your Lordship for DRC 01D for intimation for recovery to him.
Then
At
how do
his-
you recover?
And then we have attached the bank account 79.
Yes. How much is lying in the bank account?
Lying in the bank account, I think below the amount.
So
Only attachment has been made. No,
I understand.
Your
Then what? You want money or you want the business to?
money. Your Lordship.
So it's better that you get money.
Your Lordship.
It is better to get money
Your Lordship.
than to stop the business because he is a potential taxpayer who is paying you.
Your Lordship, let him pay the tax.
That is what we wanted.
Your Lordship, we are interested.
I'm ready to pay, I just pay 2 months time and I've already paid 20% of the tax liability. Should only direct revocation of the bank account so that I will be able to pay, because other personals are also there. Salary they're
Why don't you do one thing? Why don't
Money
you
is
give?
not coming to the accounts because lot of money is there with NALCO. They are unable to pay the amount because of the bank accounts.
No, I
That is
understand.
revoked so that
I understand.
pay.
Now, what is the security that you will pay?
the Lordship the undertaking can be furnished now. Not with that.
What is the security which you can give? We'll give you 2 months time. No difficulty. But what is the security?
That security that
Undertaking is not a
whatever Lordship think proper because
undertaking by whom?
undertaking by the company.
The petitioner will furnish an undertaking that will pay within a period of 2 months, 50% first month and the rest 50% the second month. Or else you'll also direct, if the failure to do so, they will take action.
Apply the thinking that they will expose themselves for a contempt. Who is a person who will give an undertaking? He is a proprietorship concern or partnership concern or a company. What is this?
Company,
Is a private limited company. Who is a director?
the managing director. Shri Kedarnath Patram, represented.
All the directors. How many directors? 2 directors or 3 directors?
Instruction.
Individual as well as the corporate undertaking both.
The corporate body will not that the managing director.
Individual as well as the corporate guarantee both.
Managing director is depending here.
Every director will give individual as well as the corporate, both.
That is what we indicate.
Attachment to the remote.
If you give a bank guarantee, if you give the undertaking, then
They will give the undertaking.
Must be indicated in the order of law, so they will give the undertaking within minutes.
undertaking has to be filed first. an undertaking specifically once they say 50% and
Within a week.
within a week, then
Oh, Malad, sir.
unless you give an undertaking, nothing will come.
Yes, yes, they'll give the audit.
Give. That's why I'm asking when.
Day after tomorrow.
Give. The petitioner has challenged.
7 and 9 months. This week.
Has challenged the several order of attachment
And 45.
issued. Again, these are all contested matters.
No, not
Directed
with
us. But on Friday, we decided not to then mention.
Yes, sir. What has happened here?
Mention appear to be very forceful or resourceful.
The last together I have assured Lordship that it will take 1 minute time only.
Yes.
What has happened there? Consequent to Virat's order passed with National Facilities Office Center Virat at page 32, annexure 3 Virat. Because instead of granting 16 crore deduction Virat, they have erosion granted at page 52. You have to be kindly see less relief allowed by CIT appeal. Page 52 Virat. Right. 10 crore 16 lakhs 99,410. But it should have been as per the operator order. You also kindly see page 55. That it deducts some deductions and the aggregate deduction supposed to be deducted versus 16 crore 47. So also directly my
friends with the KDI to take instruction. In the meantime, they have taken instruction and they have come up with the rectification order. That is in terms of that. Now they say, as per the rectification order, they have passed me. They have given the copy to me also. That 16 crore which are erroneously, instead of 1610, they have taken that into account. Now they have accounted for 16 crores. And
So what remained? Then what remained?
That's the refund to that. Only your lordship may direct to grant refund within a specified time as your lordship may. Time may be fixed by your lordship. That is the only part.
The lordship, we have already passed the order and refund has been issued. The refund has been sanctioned and the matter has been sent to CPC. And we have also raised a ticket lot. After issuing this order, we have raised a ticket with the CPC to issue the refund as quick as possible.
Only your lordship fix up this time as your lordship.
It's not in our hand. We are trying our level best, lordship, to issue the refund at the earliest.
Yes.
This order which was doing.
Item 16.
Bullions raised any time your lordship may direct for random. As may please.
Yes.
I have paid for compounding offences. They have rejected applying 59D. 59D lordship kind of glance of the section 59D. But it says penalty for mixing stress substance with liquor. And D says, it is a punishment in term of 6 months or rupees 5 times value of the liquor, whichever is higher.
59?
Lordship 59, section 59.
This is the case where the water was found.
Yes, yes.
It's what it says.
It says,
Yes.
Counter has been filed today. Copy is served.
No.
Sir,
From 29/6, notice the shop is closed. They have illegally closed. There is no inventory has been made. Nothing has been. I prayed for interest protection.
What interest protection?
For me to.
If it is some contamination is given, then you have to decide it finally.
No,
whether it is a contamination or not a contamination.
I have admitted in my reply to the smokers that there is water was added.
But I do not know what is their stand. What is their stand? What is added?
As per page number 46, which is the chemical test report, shows that at page number 47, the samples refers to about do not pass the limit test as per so and so, so and so. 46 is the chemical report test of the writ petition matters. This is also there in my counter affidavit model.
What is the page?
Page number 34.
The number of seizure is not from my shop premises. They have seized from other 2 premises, including my shop.
There is seizure from the petitioner's shop as well, Madam. I think also elaborated in.
No, description is several items which says all the samples gave positive test for ethyl alcohol. So that is there. Ethyl alcohol has to be there.
Yes, Madam. The claim is 42%. Found is this much percent.
Where page?
Page number 34 of the counter affidavit, my lords.
Where is the 42%?
They claim, my lords, the serial number 2, 42.8%. And in the
serial number 2.
Well, it's here.
Page 34.
Yes, my lords. Last column of that box, my lords.
Do not find from there.
This last column, my lords.
The right side column.
Right side.
Right side claim is there.
42.8%.
And found is 34%, 35%, my lords. Next page, my lords, at page number 35. The sample referred to above do not pass the limit test as per the ISI standards.
But these are all the branded item.
Yes, madam. Branded items.
So was there any seal found to have been spurious?
Allegation of resealing, madam.
Where is have you checked that? Have you sent it to the company manufacturing one or bottling one? Sometimes the bottlings are done within the country. raw material or the main goods, finished good comes from outside in tankers.
That they have not said, my lord, that also not found from other premises. That they found from another place which has been included in this matter.
What?
My lord, they have searched 3 places. But one Jagannath, my lord, Jagannath Naik and another is, my lord, nearby the sub
31 you can't read.
So,
Not readable.
I'll file a legible copy, my lord.
So, will you not check before filing or get it typed as well? Yes.
This was adjourned 14 to my lord.
So what? So you do not care to, then how you are placing this document?
That is the charge sheet report, my lord, which has been given in this matter, my lord. Well, I'll file a title copy, my lord. I am not able to read the documents.
So you have diluted it actually.
yes, I have admitted. In a Shokas reply, I have stated that my authorized salesman has added water.
How can you eat without sealing,
Because not
without
on
making
stock.
the sale?
Because it's on stock. The consumer demanded with water. So that is the, you know, we have taken.
No, they must have. Sir, serving from a bottle and then mixing in a glass is the one thing.
Yes.
And mixing within the bottle is the another thing. Here, the mixing in the bottle itself.
No, that mixer
That shows
found
that shows that you were charging much more.
village area, Lord.
Sir, village area.
It's village area, Lord. If it is Bhubaneswar, Lord, they are charging high.
No, sir. So what? So you will mix some water within the bottle?
Here,
You
I have taken
no,
the
sir.
stand.
I have
That
a
stand, Lord,
Brother,
they
I
have
have
not
a strong
considered.
reservation
But that
so
they
far
have
as the
not considered.
contamination
They are
is
now
concerned.
saying that
Any kind of contamination, I am the last person to agree. Be it a food article, be it any edible article, be it this liquor as well. Any kind of a mixing, sorry.
No, nothing, Lord, spurious or anything has been there.
You can't play with the health of or the life of the human being like this. Can't play.
But there is no such report at all.
No, sir.
If there is a report
that shows that you wanted to cheat your customer.
That is on
you are blaming on your the staff, but how can it be? The ultimate beneficiary is who? Ultimate beneficiary is who? You.
Yes.
So, the bills are charged. Can he give without issuing the bill?
No, there is also no allegation to that I have charged more also. Nothing, Lord, is there.
Sir, are you not realizing the thing which will be sold only in a limited manner? Now you are expanding it. Suppose if it can be sold to a 10 customers, by mixing you are selling it to 12 customers. Is it not a fraud or a cheating that you are doing?
That also that they have not alleged in my.
What are you talking about? This is what they say is spurious because the percentage of the alcohol will definitely go down in
less strength.
So that means what? That means it is sold in a measured manner.
Yes.
So the measurement is increased.
No, here it is decreased, not increased.
What are you talking? It's a percentage of the alcohol is discrete, but the measurement means in a ml or in a liter, it has increased.
But no, they have rejected applying 59D.
No, sir.
No, that cannot.
That can be 59D is.
Still not final plan.
Yes, please. It's spurious. This is what a mixing.
No, it says
noxious, whatever.
Drug,
no.
Or any other foreign ingredients likely to cause grievous hurt or death to human beings. Not that.
No.
Nothing, it is attracted. They have not found any noxious drug or foreign ingredients.
Foreign ingredients are there. Foreign ingredients will not be there. Foreign does not mean that our water is also not foreign. It is foreign.
But if I would have added anything which is the strength, then it's a different thing.
No, sir.
But and D says, if as a result of such an act, no injury is caused to any person with imprisonment for term of 6 months and also liable to fine, which may extend it to 1 lakh rupees or 5 times the value of liquor, whichever is higher. That not recovered from my.
And the sealed bottles were taken. Sealed bottles were taken. I find from the description. The sealed bottles were taken and then
24 of the counter.
No, they are not stopped.
34.
24 of the
No,
counter.
no, that is, no, it is not a case. Sorry, it's nobody should. No, sir.
What they have
No,
said,
sir.
they have written.
You are not that innocent that the court will definitely. No. If any person is found adulterating any food stuff, sorry, we can't stand in the middle. We can't stand for you. Adulteration, no, sir. Adulteration is maybe food item or any other item.
They have not videography any.
Sorry, everything.
They have not done it.
Technicalities in case of an adulteration if it is found.
Adulteration is not.
What are you talking about? You are playing the human life.
Not it comes.
Are you a human being? Are you a sensible, responsible person of the society?
Not it.
You are adulterating the food items.
Lots of
Can you imagine what disaster it may cause to a human life? And these kind of persons, you wanted that they should be treated like with a leniency.
It is not.
No, sir, because we will say this. They're fortunate enough that it has not caused any injury or it has not caused any grievous, the thing.
There is no.
There's a fortune, I would say, that has come that the human life is not lost. But still, the chemical examination report says it's adulteration.
But it is not said also.
It's an adulteration, sir. It's an adulteration.
It is not a for human concern. If that would have been there, I would not have said anything.
No, sir.
Nothing is there, sir. In the report,
everything is there.
Report,
everything is there.
They have prepared the report which they have seized from other premises. Not from the licensed premises. And licensed premises should also kind of glance. What they have seized, it is written. Page 52.
Money he's supplying to others. My goodness.
Page 52.
Sir, I can't read those vernacular things. My brother has an occasion to read, and what he is reading is again is shocking to me about your your conduct.
Lordship, for a moment, kind of glance.
Please, my mother has invited you to a particular page. I can't say that what has been written. Please go read.
That seizure is from other premises.
Sir, see what is there. He is inviting your attention to a page.
Lordship, then I may be allowed to go to the counter then, Lordship. Just now they have served, Lordship.
Because I can't read it, so I don't have that privilege.
And file a translated copy, my lords.
But my brother is reading it.
No, that is other.
And no, sir, all those statements are damaging.
Kindly glance to Annexure 9, page 50. Where they have seized, that is written, Lord. That is not seized from my premises. The other area they have seized. And that they have gone for chemical examination. Not from my sub-premises. Lordship, kind of glance. Order Annexure 9, page 50. The collector has stated everything, Lord.
The Form C2 signed by owner of the premises search. 3 persons are fined.
Yes.
And a copy is also given to you.
Lordship, kind of glance. Annexure 9, page 50.
Page 20.
Lordship will find there from what is the quantity has been seized from which place they have stated, Lord. At page 50, Annexure 9. First place seizure is from house of Jagannath Naik. There are 8 items they have seized. From another place, their seizure is about 16 items.
But what about these documents which she has filed?
That is not, they have combined all, not related to my petitioner. They have taken into account the seizure from other premises. My premises, it is there, third place. And from there, they have not found anything. That is also not there in the chemical emissions report also.
Well, a very interesting story is made up.
For para 9,
Para 7, at page 56,
in the meantime, license had given a written prayer.
middle portion.
But para 7 says, in the meantime, license had also given a written prayer to the district administrator stating therein that the two authorized salesmen so and so and staffs were illegally selling duplicate liquors outside the bar premises. But the RC roof building so and so is only 50 meters away from Sar bar, is recorded in the name of so and so.
Whose?
Mother.
Oh.
He has given rent.
For rent to?
No, she has given the rent, that premises.
To whom?
To Pavitra Jana.
Who is he?
He's accused. No. He's accused.
Who is he? He is
Not
your
really.
staff.
No, he's nowhere related to us.
Where is the rent receipt which was produced?
Not I have given. It was given before the Milord collector, but in the not read in the not then
Not
I'll
written
file it.
there.
I'll file it, Milord. Right?
Everything is there that it was totally under your control. Maybe in the name of a mother, you are having a full control of the property 50 meters away and then selling it, nothing more than that.
No, they,
Sorry.
not all that say they are saying duplicate, Milord. That is not there, Milord. If the collector says section violation 58, the commissioner says 59.
No, that is different. We are not concerned with that now. That's the police.
Let's not consider that, Milord. It is not, Milord. I have not, Milord, done.
Give it. Rule 59. Rule 59. That's B. Rule 59 of the excise rules, that is a clause B.
Can it be taken off tomorrow? Your Lordship. I have the order. Okay. You guys page 19.
1 crore.
Yeah, at the bottom, Your Lordship.
1 crore.
Yes.
Yes, then.
So the previous tender.
Oh, I understand.
They said they have made it 10 crores. And to justify my point, Your Lordship may also have a take note because they have filed the counter. I'll refer to that. Your Lordship may take note at the top, job 1. At the top, job 1, 57 numbers. Supply of 33 numbers. And job 2, 50 numbers. That comes to 140 employees. They are going to engage. This was the 2023 tender balance. Thereafter, I referred to your lordship, to my calculation as per the present tender at page 107. That's 107.
Yes.
There I indicated to your lordship, as per their own, I have given the heading minimum power requirement as per Annex 2 of the RTF dated so and so. According to that, the calculation comes to 3 crore 80. An estimated cost which is 30%. If the lordship may recollect, I referred that this.
Yes, at page.
Thereafter, 108 it starts.
83 you have.
Yes.
Page 83.
107 I indicated to the lordship with regard to the estimated cost, and 30% of that comes to 1.4 odd. So that turnover cost should have been just like the previous years. It should have.
Page 83 you were relying on that D, 1D.
Yes. Yeah, and that apart I also thereafter referred to 108. Then I've given the various notifications of the central government. I refer to 108, serial number 3. To highlight that this is what is happening, this irregularity is happening. And then I went to 109 to show to your lordship with regard to 5, Roman 1, small. Thereafter, I refer to page 111. the Honorable Supreme Court and case of Nagar Nigam and A15 meet, they have categorized in the sixth line of your lordship, see, technical specifications, estimated cost. That I highlighted that they should have indicated the estimated cost accordingly. Then I have given the GM at page 113 also, which also says 30% of the estimated cost. Now we have come up with a counter affidavit, which has no basis how they have calculated 30% and has several red flags. The lordship just has a counter affidavit. But she comes to page 6 of the counter affidavit. The lordship has already referred to that Hinsima case, technologies case, Supreme Court, Honorable Supreme Court, laid down that there cannot be subsequent justification. Okay? It has to be there in the tender paper. You can't justify. So lordship has the midline from the top, considering. Lordship has considering at page 6 the gravity of the work scenario in the future, in the template, we have decided to fix the estimated cost of ₹10 crores to meet any emergency situation in future, considering engagement of more manpower. How can that be? That cannot go beyond the tender papers. Accordingly, it was unanimously decided in pre-bid meeting so and so. The alleged allegations regarding provision of annual turnover for 30% of estimate cost as labeled against the senior accountable so and so is unwarranted justified. They have not given any indication how they are calculating it, nor the basis of your lordship has put a specific query to them how you are calculating this. So now they have come up with this explanation without any proper documentation to that effect. If your lordship comes to the bottom paragraph, further it is to mention that office memorandum of so and so, they have relied upon, it has no reference to any correlation to the estimated cost, my lords. That has given only with regard to criteria of calculation, how the eligibility criteria will be calculated, not the estimated cost calculation. Now, next page, if your lordship comes, in view of the above, I unanimously agreed to all intending bidders except petitioner. The annual turnover was fixed at ₹10 crores. It is humbly submitted in the year 2000, so the alleged tender call notice were issued. Sanitation work for Bahara Bidder and Anandabad. This is erroneous. If your lordship goes back to 98th page, this was not done. It was for both Bahara Bidder, Vitra Bidder, and Anandabad. It has three headings in that. Old tender, I showed to your lordship. So now this is an incorrect assertion which has been made here. Accordingly, the annual turnover was fixed to ₹1 crore. Now, if your lordship compares that 98th page with this one, it had 140 total manual labor. Manpower. And this has 170. So what made them inflate the turnover clause from 1 crore in 2 years to 10 crores? Now, I just for your lordship's information, I just put a query to find out that accepting a L1 bid of ₹6.3 crores against an estimated cost of ₹3.8 crores represents a massive deviation of plus 65.9%. In public procurement and government contracts such as CPWD Manual, General Financial Rules, Central Decision Commission, an award with this level of premium is extremely difficult to justify and will instantly flag a high risk of audit objections or vigilance inquiries unless extraordinary well-documented conditions exist. My case before your lordship is they have not come up with anything to show that, first of all, they have not given the estimated cost. Now, inflating from 1 crore in 2022 to 10 crores, there has to be some justification, some basis. There's no rationale indicated in the counter affidavit, my lords. Then your lordship comes to the next page. This is at page 10, para 24. The three figures for the proposed same figures for sanitation for purpose inside Sri Jagannath Temple Puri for use was considered, and since L&K Services PV Private Limited, Bhubaneswar BBG India quoted on rupees of 6 crore 31. This is with regard to that submission I made just now. They have inflated it beyond plus 68%, my lords. Decided to select L1 in transparency lottery system and all 4 bidders were implemented remain present at so and so. Now, if your lordship compares this amount to the actual, is causing a loss of 68% to the exchequer of the state, the Jagannath Temple Lord Temple, my lords. So that difference, 3.8, which I showed to your lordship on the base of the manpower, that is the estimated cost. So 3.8, where is 3.8, where is 6.63, my lords? They have given a 3+ crore inflation on that. And they have at page 11, para 25, according to lottery as conducted and so on, draw the name of BBG India. I made a small inquiry into this BBG India. May not be true, but the facts there in the Lord, you may have a look at this BBG India. I may be wrong, but this is what is available on this website. Right.
That is neither here nor there.
I may be wrong. That's what I said. My submission to your lordship is Vimsima Technologies, Honorable Supreme Court has categorically laid down. You cannot lay down such terms and conditions, which is not only discriminatory as para 18, 19, and 21, they sum up that there can be no justification like this. We start at page para 18. On previous occasion also, your lordship has also referred in another matter. Para 18 starts at para 18.
Twenty. Yes.
There is no submission since they haven't given anything on in the counter affidavit to justify that irrational hike of
Yes, sir.
10 times.
Yes, Your Lordship, may first I will explain to your Lordship that 68% hike. My Lord may come to page 107. The calculation given by the management. Assuming it is correct.
Yes.
Your Lordship may see the last line. Per annum, 12 months, 3 crore 80 lakhs. Your Lordship got it.
What is?
The total calculation per annum.
3 crore.
3 crore 80 lakhs per annum. Now your Lordship may see the contract. The notification. It is for 2 years. So it is 7 lakh 60. 631 has come. So the contract is for 2 years, not for 1 year. And second thing, my Lord, your Lordship may see my counter, my Lord may kindly come to the documents I will show. Page 13, the pre-bid meeting, my Lord may kindly see. Page 13. This is the Jagannath Temple tender for sanitation. Page 13.
Yes.
The members present. The
Page 30.
13. My counter too.
Also counter.
I'm sorry. Page 13.
Yes.
This 12 persons companies joined the and this serial number 12 is the petitioner. He joined. Also was present. So the allegation that it has been made to a particular bidder is not correct. Now your Lordship may kindly come. I have shown that office memorandum at page 14. Next page 14, annexure B. Page 15.
Yes.
Last 3 lines suggested the criteria should be fixed on a reasonable basis while drafting tender documents and such higher minimum qualifying turnover should be kept only if adequately justified. I will justify that from the counter letter. My Lord, may next kindly comes to C. Annexure C. As per the 12 bidders, these 5 bidders took part in the purchase committee meeting. My Lord may see that. Page 16. The 5 numbers of bidders had submitted so and so. Then your Lordship may see the next para. The purchase committee verified, scrutinized the requisite documents submitted by the bidders and called for the request of proposal and unanimously decided in their meeting not to consider the bidder of serial number 5 J and D, and the agency has submitted bank draft of rupees 10,000 only instead of 10,000 plus GST and submitted EMD in shape of DD, which are not acceptable and refused. Therefore, 4 bidders are considered to present their technical presentation on 27 at 11:4. Then your lordship may kindly see the next para. As per schedule, all the 4 bidders appear before the committee at 11 a.m. and presented their technical presentation during evaluation of weightage of their activities like past experience, work experience, financial strength, quality control mechanism, and technical present extra. All the 4 bidders had scored more than 70% marks in the technical evaluation. Therefore, it was decided to open the financial bids on 28/4/6 at 11 a.m. Then your lordship may kindly see next page. Accordingly, the financial bids were opened in presence of the bidders. Under authorized appointee, it was observed that Aviram Caretaking and Expert Services Bhubaneswar has quoted 30,21,000 excluding GST in Form F1 and rupees 30,21,000 including GST in Form F2 with all breakups for 2 years, stating that it's the lump sum. As there observed a discrepancy in the Form F1 and F2, the financial bid of Caretaking and Expert Services was not taken into consideration. Now 3 left. The amount quoted by the 3 bidders for the proposed CMS for sanitation work.
What is the discrepancy in Form 1 and Form 2?
You also may see there was a
I
discrepancy.
do not find the figure is one and the same.
Yeah, your lordship may see.
One is excluding GST, one is including
GST. Yes, that was the discrepancy. Then these 3 bidders were taken into consideration. 1, 2, 3. Your lordship may see the amount quoted by the 3 bidders for the proposed CMFS for the sanitation inside Jagannath Temple for 2 years is as below. Your lordship may see 2 and 3 are the same price. Your lordship may kindly see. As the amount quoted by the agencies of serial number 2 and serial number 3 are same, and lowest is so and so, the committee decided to finalize and select the L1 bidder to transparent lottery system as the Wash Department, Government of Odisha, Office Memorandum number so and so. Accordingly, all the 4 numbers of bidders are intimated to remain present at 11 a.m. on 34 in the conference hall of SJTA, Puri, for such a draw of lottery. It was also decided to complete the process in presence of the executive magistrate with videographic coverage.
No, that you have done it. You have done it in a transparent manner.
System. Now, my lord, the difficulty for the increase is, my lord, I have mentioned that in the meantime, my lords, the Delhi outflow is to the Jagannath Temple is more than 50 to 60,000, which was not there previously. So the sanitation work also includes, I have mentioned that in my counter. And Rathayatra, it is 12 to 15 lakhs. That Sunabesa also, that is more than 10 lakhs. That's always there.
What is the comparative table between 2022 and 2025?
That you are seeing.
You don't have a comparative table. So raising it from 1 crore to 10 crores, 10 times, then was there any 10 times increase in a footfall, as you are saying, 50,000, 60,000?
Yes.
12 lakhs during that.
Yes, the numbers.
What is a footfall? How much percentage?
That I have not.
Or in a multiplier, how much?
Yeah, that I have not.
Twice, thrice. So
that was
he's talking about that if there is any conditions which is imposed, which is restrictive.
Now, in the Jagannath Temple, you also may kindly see page 4 of my counter. Kindly for a minute. Para 7. Only 4 lines. There were much lesser people at that time. I have not given that comparison. So last 5 lines, it is pertinent to mention, para 7. Last 7 lines starts from it is pertinent to mention. There are varieties of works are involved related to sanitation and performing of temple rituals inside the temple premises and includes Ananda Bajar, Koili Boikunta, Nilachalo, Upavana, Rosasala, etc. for maintenance and some cleanliness. Also, my lord, now for Ratha Jatra and Snana Purnima, Chandana Jatra,
so these are the recurring the features.
Yes.
You can't say it is coming since last several 100 years. It's the same thing which is happening. Ananda Bajar is still there.
Yes.
The Ratha Yatra is being performed for several 100 years.
Yes. And since for 22.
So what is the new? Everybody knew it.
Listen, the COVID second wave in 21, 22, 23, there was not much of people, but that was 2013. I have not written that. But now in the meantime, my lord, the Delhi inflow and everything is increasing day by day. It's 70 to 80,000. It's difficult to go for that, sir. Your lordship knows. And for that reason, we all have agreed to go for 10 crores except these petitioners. Are done in a transparent manner. That is the thing.
The question is, only thing is whether it is too oppressive and restrictive to eradicate the other eligible persons who have all the expertise they have otherwise, or infrastructures available with them, they can give a quality service.
He has stated that the local operators and they are VA. Your Lordship will say the page 13 pre-bid meeting. Majority are from Bhubaneswar and VA, all are local. Not now outside us. Your Lordship see, kindly page 13. Third one, Bhubaneswar, Puri.
Have you restricted the tender to a locals or
no?
It was an open tender.
Yes.
So
yes, no, he's telling.
Have you indicated in the tender document that the preference will be given to a local?
No, he has his main allegation is this has been done to favor a particular tender. Only his allegation to keep out and give a particular tender. I am saying that is not there. It is done in a transparent. That is the truth.
So, anything?
First and foremost, rise in footfall has nothing to do with sanitation. Sanitation is regard to Vitara Beda, Bara Beda, which is quite specific both in the previous tender and this tender have categorically stated Vitara Beda, Bara Beda. And that has nothing to do with the footfall increasing every year because this is with regard to maintenance of the family, internal cleanliness of the sanctum area and the outside area. So footfall has no correlation, my lords. And with regard to that, Your Lordship, he compared my chart to page, Your Lordship may have to look at page 36 of the tender conditions. That is annual average turnover of not less than rupees 10 crores. That is annual. So contract may be for 2 years. Turnover clause is annual is 10 crores. That's what I'm trying to indicate at page 107 with my calculation, the 3.8 per year. I put it at 10 crores.
Where?
Page 36G at the top.
Oh, yes.
That is 10 crore per annum. I have told that he has told a 16% footfall of 6,31,380. That I have told 2 years. That I have told he is telling 3 lakh.
No, he says that there is a rational. If it is an annual turnover,
yes,
then at least for 2 years it will be a 20 crores, just double.
Yes.
And then you are. So this is what he says.
No, his argument was we give respect.
No, he says that annually if you take it, then it will not exceed 3 crore 80 lakhs.
Yes.
So you say that it is the contract is for 2 years, so you double it, so it will exceed 7 crore 60 lakhs. You said so, 7 crore 60 lakhs. They have quoted less, 6 crore something. But he says that this 10 crores barrier is annual. It is not biannual.
Exactly.
It's not biannual.
No. His submission was 6 crore 31 is 68% higher than 380.
So that is what he says, that it is higher.
Yes, that is
so
that is and what my learned friend submitted.
What we have to do about this judgment, because this judgment has come up, it says that conditions relating to this turnover should not be so excessive to eradicate some good persons. That is paragraph 18 and 19.
Yeah, 19, I have seen that.
Level playing field, you are offending. That is Article 14, 19(1)(g).
Yes, that I see.
That is a 19(1)(g). So,
I have seen drawing attention to page 13. So he was one of the
participants in a pre-bid meeting. I understand, but he raised an objection.
Yes.
He raised an objection.
Yes.
He admitted that he raised objection.
That's what I
Pre-bid meeting participation cannot be considered as a participant in the tender.
That's true. It is just to find out if there is any changes to be brought, any things to be done. Then the pre-bid meeting is there.
Yes.
That some conditions may be modified or something like that.
Yes. And in addition to that, my lord's 111 page Supreme Court has category that has been extracted, judgment has been extracted. It stresses on the fact that estimated cost has to be specified in the judgment.
They have not specified.
No, they have not neither specified the estimated cost, nor have they gone as per the 30% mark, which is laid down by the central government in CPC guidelines, including GM on the portal. The entire, which starts from page 108, if you lordship see. Estimated
So
cost.
did you raise that point before?
Yes, the pre-bid? Estimated cost has not been given, and now what they have done is they inflated the turnover clause. and it is not in accordance with my calculation, 3.8, 30%, it's not coming with that also. So all these points have raised my hands.
Okay.
111, you see, Lordship sees that.
No, I understood.
If you go to category later, you have to be specific on the estimated cost. And the guidelines say that it has to be 30% of the estimated cost. They have given nothing.
Where is this judgment? Is Nagar Nigam?
Page 9, paragraph 9.
Page
9, paragraph 11.
Yes. Yes, considered. Send. Keep it calm. Give it. Send it. Yes.
Item 18.
After being this irritating, I have challenged the order of the learned civil judge on the ground that the points raised before him were not considered at all. The judgments of the apex court filed before him and discussed in the court was not also referred to. My Lord may see the counter affidavit which was filed before the court at page 54 of the brief.
You are opposite party in the writ.
Yes, sir.
Who?
Opposite part number 6, the managing director, Agricultural Promotion and Investment Corporation of Orissa Limited.
Yes. You are the opposite party number 6.
6.
Directed the disbursement of a subsidy of 40%.
The scheme protected, namely MKUI, paragraph 7 at page 56. I have stated that the prayer of the petitioner cannot be allowed in law for violation of the guidelines laid down in the MKUI, in short MKUI scheme, protected for the purpose. Next, paragraph 8. It is pertinent to mention here that as per MKUI guideline F, the entrepreneur petitioner has to opt for either bank finance or self-finance for financing the project. But G, kindly see next page. However, the loan amount details will also be provided by the financing institution. The change in mode of finance after the issuance of the go-ahead will be allowed only after the approval of the district level committee. The MKY guideline G deals with completion period, which is quoted here in below for ready reference of the and better appreciation of the Honorable Court. G, completed period at page 57. The scheduled completed period of the project will be maximum 2 years from the date of issue of go-ahead letter. However, in case of inordinate delay by the financing institution in sanction of loan, the period of completion will be extended for maximum 1 year from the date of sanction of loan or stipulated 2 years, whichever is later. In delay in execution of the project beyond completion period, the deduction will be carried out from the eligible CIS. Completion delayed up to 6 months, 20% of the CIS will be deducted. CIS means capital investment subsidy, which is claiming, deducted from the eligible subsidy. Completion delayed beyond 6 months to 1 year, 50% will be deducted from eligible subsidy. Completion delayed beyond 1 year, no subsidy. That in the present case, admittedly, go-ahead letter was issued in favor of the petitioner by the Chief District Veterinary Officer, Nodal Officer, Ganjam Barampur, by letter number so-and-so dated 25/5/2001, which was valid till 25/5/2003. He could not complete the project within the period stipulated in the guideline, that is, within 25/5/2023. Kindly see, I am giving the guideline.
Now the question is whether this Supreme Court judgment extending or suspending the applicability of the limitation applies to a contract also. Does it apply to a contract?
But this is the guideline. G, completion period.
The learned single judge has relied upon a judgment of the Supreme Court, that is a suo motu case, where the period of, during the COVID time period of limitation.
That was not there in the pleading. That was not there in the pleading. Then he was
Does it apply? It says only the general law or the special act. Limitation is provided.
Till today, he has not applied for the CIS, Capital Investment Subsidy. Kindly see.
No, he made a representation claiming that before you. That should be treated as an application for grant. In an earlier writ petition, he was permitted to make a representation and claim. You rejected it. They challenged that order.
Yes.
So, what did not apply means what?
On the ground that non-compliance of the provisions of the scheme. That is there, and clearly it was.
He says that I have obtained the loan and there's nothing.
I don't know, see, page 7.
Which was the other side?
Page 7, Alex.
The notice has to go.
It was
to the writ petitioner.
It was downloaded on. It was
notice has to go to the writ petitioner.
Opposite respondent number 1.
Except 4 series. Towards right side.
Respondent number 1.
Pending.
Respondent number 7.
Pending of Formal
respondent number 1 and respondent number 7.
5,
activity
5 also.
overdue by 184 days, 100% penalty since March 4th,
You
March
are appearing
2022 to 5.
Preparing for
2, 3, 4, 4,
Notice to the writ petitioner.
5,
No, but it's actually considering.
Both
5.
IA and both.
Well, no finding was even, and I am also today submitting another decision of the Honorable Apex Court.
Sir, we have issued a notice, let them come. Without hearing them, we cannot do anything.
Yes, ma'am.
Let them come. Reopening.
Item 19.
Kindly stay on proceeding because they have already filed the contempt.
Whatever, you were there, January, you were there. Order is passed in January, so we are keeping it on a reopening day.
19.
Yes.
But I may be permitted to take notice.
Both in IA, I have already said. To the writ petitioner, you'll have to.
This appeal has been filed challenging the judgment partially on its individual at annexure 1. The grounds for appeal by law, only on the point of law, the lawyer signature failure. The deed petitioners all along claim that they have got the deed property in pursuant to Way Bandobast case in pursuant to section 8(3) of the OER. And in section 8(3) of the OER provided clearly says deed property cannot be settled in favor of the
What? What property cannot be settled?
deed property. Trust estate.
Trust.
Trust property.
Trust property.
Section 8, subsection 3 provides of OER.
What trust? What is the nature of a trust?
Lord Jagannath, Vijay Itamati in the district of Niagara. Jagannath property.
Is a trust or it is an endowment?
Endowment property, madam.
So,
Endowment property. Endowment property, during midst of the hearing, Commissioner Endowment was a party to that issue. But in the judgment, name has been omitted now. And this DT is an index DT. Non-hereditary trustee is also there in pursuant to the order passed by the Endowment Commission. But section 8(3) of the OER cannot take away the property of a DT. For that, Orissa Endowment Registration Act in 1951. At the same time, when Orissa State Abolition Act was enacted. So the property of the DT is to be taken care of by the Commissioner Endowment in pursuant to different provisions of Orissa Hindu Religious Endowment Act, 1951. But the property has been taken away by an administrative authority, none other than the Tahsildar, who is a collector, vesting the property in favor of the respondent who had the writ petition. The order was challenged before the Board of Revenue. And that order was passed. And that was under challenging writ petition. And in writ petition, one single judge hold that, no, the order passed by the Board of Revenue cannot hold good as because the order passed by the OE Act cannot be adjudicated by the Board of Revenue. That is the whole anomaly in the moot coaching for section 8.
what is this OE Act? OE Act means?
Orissa State Abolition Act. After independence in 1951, the state was vested in government, so the act was enacted. At the same time, Orissa Hindu Religious Endowment Act was also enacted to safeguard the property of the deity. And it is a property of Lord Jagannath. And relying on the judgment of the Apex Court, it was though discussed, but it was not considered by the Lord Jagannath.
आणि ऍडमिशन मला
Brother. Notice both on I and split.
पर्सनल प्रोड्युसर ऑर्डर डू मला दे आर क्रिएटिंग डिस्टर्बन्स इन द ऑर्गनाइजेशन ऑफ द DTP.
Come. There was no interim order during the pendency of writ.
Item 20.
Protection success charges पुढे मिळा.
Come.
Put the subs of the
Once it is settled, the position is with them.
No, my lord. Position is with the hospital. As on date, position is with the hospital. That is
We can't say so.
Item number 20.
Returnable after.
The punishment that was imposed was challenged with the Honorable Single Judge that has been confirmed by its reduction of 5. The appellate to your lordship working as a sweeper in the bank. It is alleged that he got a ATM card and had made some withdrawal. Subsequently, he was asked to deposit and he made the deposit. And thereafter, a proceeding was initiated against him. And at page 43, he was asked to submit reply. He replied saying that he had no knowledge, but he was asked to deposit and he had deposited. However, the reply was given on 9/8. Now on 10/8, an undertaking was taken from him.
It is only whether it is disproportionate to the charges. What is the charge?
The charge is that he had made some withdrawal through that ATM which he got while sweeping and which he re-reported as per the directions. That was the only thing, my lord. No. That is
Compulsory retirement.
It's true, it is, my lord, but
what prompted you to use the ATM of another? How could you get the PIN number? That means you were keeping watch. Unless you get a PIN number, you can't withdraw from the ATM card, which you found during sweeping.
No, my lord, in fact, it was never given to that person. While sweeping,
Sir, I understand. By sweeping, he got that card. First misconduct is that he used the card for withdrawal. Second thing is, how could he get to know of the PIN number? Without the PIN number being put, no withdrawal will be permissible. That means you were watching and the moment you found.
May I just point out one thing? When I was called upon to submit a reply,
you have admitted. You admitted your guilt.
I denied.
No, sir.
In writing, your lordship may kindly.
Annexure 5, where is that?
Page 45, your lordship may kindly see. Then, my lord, I'm undertaking.
Let us see.
This was filed on 9/8.
No, sir. It may be subsequent there too by virtue of any other mode.
May I just only clarify one thing? On 9/8, I filed a reply saying page 45, only page 45. I said that I am no way concerned. I was asked to deposit. I have deposited. I have never used. Your lordship may kindly see what I have written. Now, on 10/8, another undertaking is taken saying that I have committed a mistake and I will never commit that mistake again. Now, my lord, then the proceeding was proceeded and I have been saddled with this punishment. Your lordship is 9/8, I give a reply like this. On 10/8, the next page that is in Oriya, my lord, therein, as if I have admitted my fault and.
That is what is the Inudia. I can't read it.
I'm sorry, madam.
My brother will read.
There has been an admission on 10/8. 9/8, I file a reply saying that I am disputing.
So you can definitely, there's a good sense because you may have been advised to go for that. Later on, his conscience does not permit. So he himself wrote and say, yes, I have committed mistake.
That I have said, my lord, that was out of, my lord.
No, sir.
Because of the imposition.
No, sir.
Because on 9/8, my lord, your lordship says I give a reply. On 10/8, this comes as if I have admitted everything. Then on that basis, my lord, it has.
What is your age?
35. 35.
How many years of service?
My age is 25. 25 or 20.
You will be getting a pension and all, everything.
Because you can only consider the disproportionate part of it.
No, this is absolutely.
And
3,000.
Vacation. After vacation.
I have placed. To say that when your lordship takes a view, I will say that will not be fair
The instant appeal
to the honorable.
arises from an order dated 18/3/2026.
If your lordship would
By
have
the single bench.
kept it for hearing that.
The single bench. By which the writ petition being WPC
May I give you the option? In item 21, I'm challenging the influence judgment dated 19th of March 2026.
Where it is?
Annexure 4. But prior to that, can I please?
Annexure?
Annexure 4, page 1.
Please give me page number.
Page 125, your option.
Yes.
But prior to that, can I leave your option?
Just 1 minute. 125. Just give us 30 seconds time. What is the order of the tribunal?
Page number 67. 7, it starts with page 68.
No, just
Minus.
Just one. 67. Oh, Annexure 2. Yes. Where is the operative portion of your
option? Page number 73. Para 7 is the
just yes. You are representing whom? And
state of the
so you represent all the respondents. Answer. There is a distinction. A mere direction to complete the proceeding within a time frame. If it is not done, it does not really invalidates the entire proceeding. Settled. But if it is coupled with the consequences to follow, then in that event, if it is not complied with within the time frame, then the consequence is automatic. Here it says that if you do not dispose of, then it will be deemed to have been dropped. So that's the consequences which is provided. So dropping means that you can't proceed beyond that. It says that you have filed an application for extension, but that application never sees the light of the day, nor there was any order which was passed. So maybe you have taken out, but that does not mean the order is passed. You should have moved it.
In similar circumstances, the guidelines of the Honorable Supreme Court is there, Your Lordship. If you will permit me, I will just place that.
What guideline?
Yes, Your Lordship. That when the tribunal or this Honorable Court fixes a timeline for disposal of a disciplinary proceeding, it has to be followed till teeth. And unless and until you don't dispose of, there's a certificate of law, Your Lordship. If Your Lordship permit, I will show the judgment also.
Show it, but I don't think so. There can be any, what you are saying is the law.
Yes, Your Lordship.
I don't think so.
The recent judgment.
It simply says that a committee and the amity of judicial discipline has to be followed.
Yes, Your Lordship.
That does not mean that if there is no consequences provided, so it will automatically go.
coupled with the consequential.
That is what is the most important factor. If it is coupled with the consequences, then the situation is different. Yes, Mr. Das. How? Brother. This is both things.
Kindly see para 7.3.
Yes. If the authority is given a mandate, how?
Para 7.3 of the improved order.
No, it says in anticipation that it will be extended, but it has not been extended as of now.
The Honorable Court has watched the order of the punishment as well as the order of the appellate authority confirming the
fresh.
How can it be? How can it be?
Already dropped by virtue of order of the tribunal.
Retiring.
It's also going to retire.
Then how can we resurrect it? That.
Mr. Law is well settled in this regard. Had that line feeling which not there, you have a good case. I was just listening to him, just going to that.
This came because of this.
Because of dereliction earlier, that conduct was reflected.
The law which my Chief Justice said that exactly that is the judgment. Exactly.
Page 14, Your Lordship. Paragraph number 7. The issues were framed by the Honorable Apex Court, and so far as the present case is concerned, issue number 4. Page number 40, issue number 4.
Yes.
Whether the inquiry not having...
Where is the answer?
Yes, Your Lordship. The answer is at page number 63, Your Lordship. Sorry, page number 54, para 62.
Unless and always fast.
Same thing.
And 64, para 64 is the conclusion.
Paragraph 62 last.
Yes, and 64.
It is very clearly says that finally we hasten to add that if the tribunal or the court stipulates a fixed time by which an inquiry or proceeding for disciplinary action ought to be concluded, coupled with the rider that in default the inquiry or proceeding will stand lapse, which is the same case here. The disciplinary authority in such case would cease to have jurisdiction to proceed further, unless, of course, citing a genuine ground, a recall of such default clause is sought and obtained to proceed further in accordance with law. So unless you get an extension.
But our extension application was pending.
You did not press it. You should immediately stay away with the disciplinary proceedings, keep tight, and then ask for an extension. The moment the extension is given, start. But you can't proceed because you loses the jurisdiction.
Para 64, that exactly that has been said. Unless and always without an extension. Without an extension.
No, that's what I'm saying. Without proceeding further, he ought to have. Should stay with his hand. Small. Don't quote the prayer and all of it. No, it has to go. Yes.
Disposal.
Yes. It has to. No, just citing a judge. Yes. This court, this is the consequences, this is what is there. Just opposite to one.
Item 22.
Judgment of the senior judgment starts from page 38.
If that public applications were disposed of.
What has been said?
But the only question that was whether revision is permissible or appeal is permissible. In an application filed under section 22 of the, so kindly come to page 13. Where an order passed.
Yes.
Where an order passed.
Yes, 38.
Well,
Oh, whether an order passed in a mutation appeal.
Under Rule 42 of the Orissa Survey and Settlement Rules 1962 is revisable on section 32 of the Orissa Survey and Settlement Act. Read with paragraph 111 of mutation manual. Under the Honorable Single Judge was conscious of the fact that there are conflicting judgments. Well, kindly come to page 43. 43.
Yes.
Para 10. As against the contention noted above, and Senior Counsel Mr. Mahanti submits.
So that's the submission.
No, there are conflicting judgments of this court. He refers to a judgment of Jayashankar Vagdova versus Collector Puri and others, and the judgment rendering Sushant Kumar Das versus Sub-Collector Bhubaneswar and others by a cornered bench of this court. In the first judgment, it has been held that the order passed in mutation appeal is not revisable. In the latter judgment,
In a latter judgment says revisable. So that's a submission. Two judgments were cited. Then
no, the Honorable Single Judge Mellot finally come to the conclusion Mellot page 60, para 30.
60.
Yes.
Yes.
Para 29 Mellot have said that this court, after analyzing the certain provisions and the scheme and object embedded therein, as narrated herein before, feels persuaded to follow the reasoning adopted in Sushant Kumar Das, the latter judgment, and holds accordingly. Thus, from a conflict.
This is a latter judgment.
Yes.
Shushanto. And what is the Jayasankar?
Jayasankar, my lord, Jayasankar said, and
Jayasankar is 2004, volume 1.
Yes.
And
we have got all the judgments.
2013 judgment is there.
Yes, sir. Jayasankar, my lord, 2004, 1, OLR 538. My lord, can you see this?
Who is for the other side?
The state.
What is this? Sir, the only question is very simple, pure question of law. If there are two conflicting judgments, then what the third bench should adopt? Which judgment has a binding force? Earlier or a later? Latter?
Earlier. And here another judgment has come. Another judgment was also made the first judgment, following the first judgment.
I just reminded myself of that community of Daudi Vora Constitution Bench decision of the Supreme Court, 5-judge bench or a 7-judge. I do not remember, 2005 Supreme Court.
Judgment because
Subsequently, 2007 also the judgment is there. And then I think 2023, there is another judgment. But that is the parent judgment of Constitution Bench, where it says that if there is a conflict between the two judgments, then in that event, the latter judgment cannot be held to be a good law because the only course available to a coordinate bench is to refer the matter to a Chief Justice to constitute a larger bench. Otherwise, you can't do it. The earlier concept of the Privy Council is different. There was another view, very interesting view of the Calcutta High Court taken in Bholanath Karmakar, where the division bench says that if there is a conflicting judgment of a coordinate bench, then the facts parity principles have to be applied. The one which is very close to the fact should be adopted. But I think after this Daudi Vora, everything is gone. That judgment is also no longer a good law. What to do, sir? How can a judge take a latter judgment view? Whether the Susanto judgment took note of the earlier judgment of this Agarwal?
No.
Then can't be said to be per incurium. Susanto?
Sushant Melod has not seen Melod. There are earlier two judgments, but Sushant judgment Melod has not followed any of the terms.
No, sir. Susanto judgment, I am asking if it does not notice the earlier judgment in what is this?
Yes, sir.
What is this? Jairam or something?
Yes.
Jaishankar. If it did not notice, then in that event, Susanto is a per incurium judgment, unnoticing the earlier judgment on the same point.
Practically, paragraph 25 and 26.
What?
Discussed.
What discussed? What he says? He has gone on a fact parity that Susanto appears to be, to me, is a correct law. So I go by Susanto. But the Susanto judgment is contrary to Jaishankar. Sorry.
And Susanto refers to the earlier two judgments.
The later judgment which has not taken consideration.
That's a per incurium theory.
So it will be per incurium and
It
the
was.
earlier judgment will have
Prevail.
unless and until the
Have you brought those line of judgments which I am saying?
Yes.
What?
There are two Supreme Court judgments, 2001 Supreme Court 383.
What?
They have said, Melod, the only courts available to the other single judgment on knowing that they
Have you not brought the constitution bench decision in the community of Daudi Vora?
No, I have not.
I think it's a 5-judge or a 7-judge bench. 5, my gut feeling says. Of 2005, volume 6 or 8 SCC. Community of Daudi Vora. Or a Daudi Vora community, I do not know.
Like at page 67 and 58, you may refer to me. Right? If it is discussed, the SEO decided in the case of Jaishankar Agarwal is completely different from the case. That's it.
Sir, in Jaishankar, it is held that it is not revisable. Is there any conditions? Or a revisable, I do not know. What has been held? Jaishankar?
Just contradiction.
Sorry? Revisable or not revisable?
Melod, not revisable.
Not.
That has followed in Maheshwar Naik, that was also seen Melod by the Honorable Signature. That says not revisable. And they have given reason. And in Sushant Melod, no reason have been given, but only clarification of a judgment for.
Have you got that?
Central Board of Daudi Vora.
That's true. Central Board. 2005.
Five judges.
5-judge bench decision.
17th December.
Daudi Vora.
Central Board of Daudi Vora versus State of Maharashtra.
Sir, can it stand on that parameter? So what has happened? Your
Have given
your mutation is denied or allowed?
in my case, Melod, mutation was not allowed.
Not allowed. So appeal also dismiss.
Yes.
Anyhow, there is no question. Come when on the reopening come ready. Any other person to be given a notice? Who? The person in whose name that is there.
Only bank Melod, page 5.
Yes, respondent number 5. Respondent number 5.
Whose name was appearing in the record of right? Have you made him a party?
So record rate,
It is purchase through.
I am just saying under the surface, the auction was done, I know. But I'm saying that when you went for a mutation, there must be a name recorded earlier. Maybe a borrower, maybe somebody else. So I am asking you whether you have implemented them a party.
it was not made a particular.
So
Because certificate of sale.
I understand the certificate was done by taking recourse to this Rule 8 of the security enforcement rules. Understood. Section 13(4) action has been taken. Anyhow, serve the notice on the bank. Have you got that?
The bench of lesser quorum cannot doubt the position correctness of the view of the law, not taken by a bench of larger quorum.
Correct.
In case of doubt, all that the bench of lesser quorum can do is to invite the attention of Chief Justice and request for matter being placed for hearing before a bench of larger quorum than the bench whose decision has come up for consideration.
Correct.
It will be open only when
Both the bench are police. Yes.
draw your attention so that you can.
Item 23.
Only interim provision will be,
What into production?
I'm in position.
So protect it. Who says mutation does not create any right? You have a self certificate with you.
Well,
23.
Yes. Who is appearing? Issue a notice, immediately file a requisite so that we'll go to the magistrate. It's called the
23.
Yes, which is the impugned order, Mr. Doloy? Only 2 minutes.
I can conclude with 2 minutes.
Yes, where is the impugned order? Where is the impugned order?
Let's come to page 89, annex 2, Lordship.
Page?
Page 89,
That's
annex
the impugned order.
Lordship. It starts from page 92, Lordship.
Page 89.
There, Lordship, only my submission.
Just 1 minute.
Sorry, sir.
I have not reached.
Page 90.
Just. Yes.
Lordship, just I will come to my second point, Lordship.
Already a judgment is delivered in 39518.
That is my entire case of Lordship. Because there are full bench judgment, Lordship, division bench judgment, and 3 coordinate benches have given the same judgment, holding the collector has absolute no authority, but honorable single judge, bypassing all the judgments, Lordship, division bench judgment, full bench judgment, and 3 other coordinate judgments, Lordship, has by this order is compared to judicial discipline, Lordship.
What? Judicial?
Discipline, Lordship. Lordship, can you say I'm giving one judgment, Lordship, a recent judgment, Lordship.
can receive. 2024, I have a catena of judgments, Lordship, just I'm referring the recent judgment. Then I'll come to the facts, Lordship. Facts, Lordship, I have a very good case which has been
What
committed.
catena of judgments?
Lordship, this judgment, Lordship, it is.
What is this? Judicial discipline. Who says?
Lordship. Just I'm reading only first paragraph, last time, that is also para one, Lordship. The rule of judicial discipline and propriety and the doctrine of precedents has a merit of promoting certainty and consistency in judicial decisions, providing assurance to individuals and to the constitution of their actions. The constitutional benches of this court have
Same principles which the earlier matter was.
Lordship.
So,
Lordship, kindly see that I'm giving the judgment. This the catena of judgments of this honorable court. All the 6 judgments I have brought before Lordship. Not to
I know the parent judgment only,
Lordship.
which is a foundation.
Objection, Lordship. No, but Lordship, I have brought the all judgments to my
Have you brought that constitution based decision? No.
Lordship, I have brought.
Which I referred in the earlier matter.
Sorry, Lordship, but I have brought Lordship Central Board of
That is a Dowdy Vora,
Lordship.
2005. Volume?
Lordship, then
Volume 6 or 8.
Lordship, this is Lordship volume. Lordship, I have got this.
SCC?
Volume 2, Lordship, that is.
Volume 2.
2. Honorable Justice R.C. Lahoti, Lordship. Shivraj V. Patel, Lordship. K.G. Balakrishnan. Then, Lordship, I am referring to Rajasthan Commission.
How can it be, sir?
Principle will not be applicable to the present fact of this case.
Oh, sure.
Because the judgment which has been relied by the single judge, they have discussed all earlier judgments and passed this on.
If they discussed all the judgments, and a contrary view is taken, will that judgment be correct?
And they said earlier judgments are per incurium judgments.
Okay. Earlier judgments are?
Per incurium.
Per incurium to what?
Per incurium judgment, they have given the disclosure.
Per incurium to what? There are 5 or 4 or 5 principles of per incurium to what? Tell me.
How this per that has not been discussed, but they discussed.
Then how can you say? Yes, no. Come after vacation notice.
Stay, Lordship.
What is stay?
Lordship, that is a proceeding against me, Lordship. I am 4 months left to retire my service from retirement service, Lordship. Only because because Lordship, I approved this one would challenge my transfer order. It has been stayed by this one before the collector issued Lordship for proceedings, Lordship. That is comes to.
Let it proceed. No final decision would be taken.
Lordship.
No final decision. Because if we blankly stay and ultimately if we find that no collector has the power, then ultimately that's all.
Ma'am.
The appellant was the prisoner in the restriction measures.
What is this,
And the appellant.
PP Central Odisha Distribution Limited? What is this organization?
It's my electricity distribution.
Central Tata Power has taken a recall.
Is a statutory authority or having a control of the government or what?
One of the judgments
It is a
say that it is Article 12.
12.
Tata Power is Article
Yes.
12.
Yes. It's coming under Article 12.
This court decided that.
Yes, yes. In NESCO. Yes.
Only thing is that you are also a trade union, you were spared, you were not asked
Yes, my similar.
for any opinion, other trade unions were called.
Yes, yes, my.
So that is your grievance.
Yes, madam. I only want my representation where I have given some proposal for consideration only may be considered by the management. And for that purpose.
What is this?
I did not be a recognized union.
What?
Yeah,
This is how it means.
There is no power under the law. Consider I am a registered union. And other unions have been invited for discussion.
Union?
Yes, madam.
Where you have stated.
I have filed that certificate by way of an additional article in the restriction.
You are not a recognized trade union?
There is not a single recognized union under the organization, madam. All are registered unions.
Issue notice on the TDPL.
Paid for interim.
What interim?
No final decision.
No, sir.
Taken because
Let him take. You can't stall the entire thing. No. That is on 23rd.
Otherwise, it will suffice my last. It may
23rd or 22nd?
directed to
22nd.
22nd. No, sir.
It will suffice if my recommendation is only directed to be considered before taking any final decision. That will suffice.
What cannot be achieved directly cannot be permitted to achieve indirectly.
If they take any final decision,
That's all.
then the purpose.
No purpose is there. Let us see.
Item 25.
Yes. Yes.
I'm appearing for the respondent number 2 on caveat. I have not been served copy.
There's a caveat.
The appellant, Manoj, I immediately serve copy of my writ appeal, Manoj, on both the opposite parties, 2 and 3 lines.
So why you did not serve it earlier? What is the purpose of the caveat, sir?
I should have, Manoj, but I was out of place and I arrived.
So whatever.
The reason.
What do you want?
Give us the date so that I can.
Tomorrow or I'm ready. Yes.
Item 26.
Respond number 3. The serial number 25.
Condonation is there.
Well, limitation is not there.
No, next matter. 26.
That is condoned. That is condoned. I will.
Condoned means?
That limitation, they have filed a delay.
Delay or already condoned the delay. And that is not final hearing.
Not final hearing, my lord. This press admission. My learned senior is the one. What's
It means for the hearing. That is.
Come after on 22nd. 22nd? It's 22nd.
22nd.
The reopening day, sir.
Item 27.
So after notice. After notice.
Nobody is appearing.
Appear
after vacation. Then appear.
Item 28.
That is, keep it 1 week after.
Yes, sir.
28.
28.
What is this? What is this?
petitioner has approached the Supreme Court for unutilized 300 days leave, my lord. The principal amount was paid, but the interest was not paid. And for that, the second petition was filed.
What?
Under the 300 days unutilized leave salary, my lord. The
So
petitioner.
you earlier sought for the same release in the earlier writ petition.
My lord.
Then how the second writ petition lies?
My lord, because it was ordered to consider the representation. And after that, a contempt was filed. After 4 months, the principal amount was only paid. The interest upon that was not paid to us. For that, a fresh cause of action was arose. And after that,
Where is the earlier order disposing of the writ petition? WP 26423, where is the order? 17/8/2023. Where is the order dated 17?
Wait a minute. But it should have answered 5 days.
Come ready after vacation, madam.
Same. That was made request. But they defined the decision to consider.
and the recommendation was that the petitioner is eligible to be paid the 300 days unutilized leave salary.
Together with the interest.
My lord. My lord.
That was the recommendation, together with the interest.
My lord, just the unutilized leave salary because he has not availed it. But my lord, the petitioner's contention is that, my lord, as because there was a delay of so many years of a decade after his retirement, the state is
Come with the principles of Section 11, Explanation 4 of the CPC.
Last occasion, my lordship,
You have to just satisfy with that.
to find a Supreme Court judgment, my lord.
Yes, Order 2, Rule 2 also, I do not know whether it will
You
have.
had
any-
prayed for in your writ petition. What was the direction given in the writ petition? What was the recommendation that you come prepared? And earlier judgments of
Please
this
come
court.
with the lines, what you prayed, what was granted, how it will not impact. Please go and consider that.
Item 29.
Keep it up. application.
Yes, sir. Maybe pardon and 27 of the lawsuit on this.
Yes.
This writ appeal arises of a writ petition. As per order has been challenged. Kind have a last year started 4/5/2026, my lord. And I am reading out the paragraph 2. We find that the documents contain advisory and confusion is created whether the same is an outcome of various states and the treatment which has to be undertaken, and therefore we feel that the appellant must undergo extensive examination by the psychiatrist as an independent.
What is happened?
India is appearing in this matter in the last topic.
What is it?
Yes, my lord. This is the latest communication by the department, my lord.
What communication by the
Yes, ma'am.
department?
The
The hospital and the detailed report.
They have not taken me, my lord. Rather, I have issued a letter to the IG to take me for treatment, my lord, for checkup. But this letter will help me, my lord. In this letter, the brief history has been given, my lord, but the operative portion is at last paragraph. Paragraph number L.
Apart from the above, it is also informed that there is no government accommodation available in this unit that was there, in which above psychiatric patient with his family can be accommodated.
Then what happened? Then what happened? Is a recommendation. Then what has happened?
That the DSA said that there is accommodation is available. But here this letter is clear that there is accommodation is not available.
Right. It is not yours. Sit down.
It is not available. Now,
There is a learned DSG. Keep it tomorrow. He is not here. Inform, give him a notice.
Item 30.
tomorrow may not be supplementary.
Item 30.
Condonation of delay has been done.
So 1 day delay.
Whatever. A right has accrued to oppose, sir.
Right.
You know the civil law better.
I have sought the copy.
So what do you say?
1 day delay.
Yes, this is an application for condonation of delay.
Orders were supposed to be passed. Dictating as you.
No, we have. Miss the bus. Hey, yes, where is he?
Item 32.
Can you accept the application? This is what we wanted. Otherwise, we have to direct the service. Huh? Yes, sir, the copy of the interlocutory application. So tomorrow, then let him come. These are the application for condonation, no difficulty.
Item 33.
Hello, sir. Item 33, I am on receipt for appellant matters. As per your lordship direction, I have already served copy on the respondent number 1. Within 2 days, my sir. As per your lordship direction on 23rd March 2026.
You know what has happened?
Respondent number 1, no one was appeared on behalf of respondent number 1.
Is appearing.
It's private party.
So where is the affidavit of service? Where is the service?
I have served in copy matters on 26th matter.
But you have not filed anything.
Yes, matters. But I have served him copy and he has received the matters.
Not yet filed. Then you file it, sir. Unless that is recorded, how can we proceed?
On 26, I have served him copy. I have a copy there, matters received with me.
But you'll have to file it, sir, in the department.
Yes, matters.
So when you can file? Because there must be something on record where we can proceed against him ex parte.
Respondent number 1, my lords.
When you can file?
Yeah, I have filed. I have filed.
Mr. Nanda, question is when can you file?
The receipt showing the service.
Yes, immediately, my so tomorrow I can file.
Yes, file it. Put it on reopening day.
Yes.
Yes.
Item 34.
Yes, ma'am.
Last occasion I sought a copy to my lord. I have filed the objection, my lord. After file, I have filed the objection.
Service. It is in Service. 36 is also condonation.
139 days.
Or whatever. The service has to be affected. 37.
Item 37.
Yeah, then, my lord, yes, sir, pointed out, my lord.
We'll have to.
There is no deal, my lord. Yes, sir, pointed out, my lord. I've held below consideration, but the SR pointed out, my lord, there is no deal.
Then what? Are you ready with the matter or should I keep it after? After. Yes.
Item 38.
On the area of 118 days. Service has to be affected. Yes, service.
Item 39.
These matters all 1 week after.
Item 39, I am on virtual mode, my lords.
Yes, there is a condonation application.
And it shows that postal tracking report shows item is in transit. Flag C.
Oh, so then come after vacation.
My lords, there is another miscase which I filed under Order 41, Rule 27.
Oh, this then service you affect that also because it has to be heard along with the appeal.
Yes, my lords, there's a request. Can it be because there is a contempt has been issued against the chairman.
We are keeping it on a reopening day. This 3-4 days, nothing is going to happen.
Can it be in vacation?
Contempt cannot be taken up during vacation. Come after that on the reopening.
Item 40.
Service upon Order 41, Rule 27 application. 40. 40.
Item number 40.
State of Odisha. What are you doing? Service.
41.
Filing. The requisites put in beyond the time stipulated in the order be accepted. The office is directed to effect.
The delay 278 days more.
Service.
Item 43.
The number 43, caveat matter is not.
Sort the copy. How many days delay? What do you say? Delay opposing?
My lord, we're not opposing to delay, my lord, but we have just received the petition just in the court, my lord.
Now you wish to file objection to the condemnation petition?
No, she's not opposing.
Not opposing to that, my lord.
So we condone it
My lord.
and fix it for admission.
My lord.
Yes.
This matters of matters going on.
Now, why you are late then? Contempt proceeding. You will come late, invite these kind of a situations and then say contempt proceeding.
And
it will not, I am not wrong, my perception, that this appeal is filed after the contempt notice is issued. I'm sure. Is it? Yes. Yes, condonation, reopening, admission.
Item 44.
Condonation service. Service 1 week after vacation. Yes.
Item 45.
Yes.
Item 46.
Service, who is appearing? 46, who is appearing?
I am for the opposite. I am for the opposite party.
Opposite party. Appellant, Mr. Indumani Sahu.
46, sir.
Anyhow, none appears in support of the petition. Let it be listed 2 weeks out.
Item 47.
Please, Your Lordship, in item 47, my lord, there is a delay condonation application. We have already placed it.
Have you served the copy?
The private party is copy number 1, my lord. He is the contesting party. He is the writ petitioner.
Yes, so have you served the copy? No.
So notice has to go, my lord.
Yes, notice 1 week after. Service.
Item 48.
With due respect, my lord, we have filed an application for stay of
What is this? Condonation. Serve the copy. Serve the copy first.
Case number 18, similarly.
What?
48.
This is the condition application you have to serve.
Delay is condoned.
206 days. So you'll serve the copy of the condonation. Serve.
No, the copy has already been served. He wants to
No,
file.
he says not served.
I've received the copy. I filed an objection.
Okay. Mr. Rata, please for.
Sixth.
Objection or counter, I do not know. What is the word?
Yes, certainly.
Item 49.
49, my lords.
Condonation. Condonation. Condonation.
4 days.
Every right has accrued even for a day to oppose. So service, you are appearing or dispensing case?
May be served. It can serve.
I think notices had gone. Notice had gone. So appearing for steel authority. Steel follows.
He is the only person.
He's the only person.
So
If I can request for a copy.
name that appears in seeks. You appear with whom?
With Mr. Dev.
Dev.
Six direction of
Item 50.
41 days delay.
serve. Notice. Next.
Notice to private citizen.
Oh, what was notice has to be.
Item 51.
Yes, notice.
Rectification on.
You serve a notice. Yes.
Item 52.
Service.
There is a delay.
Service. Service of condonation application.
Notice has to go with the
Go. Yes. Next.
Item 53.
delay of 254 days.
Notice. Yes.
Item 54.
What is this? How many days delay?
I think item number 53.
Uh,
Retable is not maintainable.
condonation has to be done first. If it is rejected, rejected. Yes. 54.
126 days.
Service. Notice that is. In Calcutta, we call it a service. Means the service of the application has to be affected. Sorry, I have to amend. Notice here. Okay. Notice.
And the second one also.
So many years of.
That is 127 days.
Yes. Same notice.
Great.
Item 56.
Extra
days matter.
Yes, what is this?
Fridays.
In view of annexure 6/46, Lordship only to pass the order, I will not open my brief and Lordship.
Pardon us before the vacation.
Small order, Lordship.
You remember anything?
The petition.
Due to serious allegation against the petitioner, the IMFL office was closed. It was seized in that building and the office.
What serious allegation?
Serious of selling the IMFL. Yes. Victoria is illegally selling the because it was seized. After seizure, the notice was issued to him, and thereafter he has filed an application for release of the building where he was operating his shop on shop. He has said that my building is for lodging and other purposes. If you want to seize the on shop, you can seize it.
In fact, Lordship, the issue which was set at rest, Lordship, since long, because the collector was not polygamous with me, Lordship.
No, that is the story he's saying also.
You made a.
At what point of time? At what point of time there was?
Now what happened?
Let me complete one line complete. I am a cancer patient, Lordship. They are very calm, Lordship. Within one more, 2 more, they will pass out. He will pass a Lordship because he is suffering from last stage of cancer, Lordship. Last stage of cancer is bedridden. Lordship, person is fighting this battle, Lordship, since last 4 years. And because the collector was not fully with me, with a stranger allegation, a person who is stranger to the case, Lordship, made an application by making a first signature that 1 decimal of land is with my hotel. The collector came and seized my hotel, Lordship, and cancelled the option. So in the meantime, Lordship, your Lordship, Peru's Annexus 6, the inquiry report excise commissioner is completely in favor of me. Last time, Lordship.
Correct. Then.
So now they are, Lordship, what they have done, they have now opened my hotel. They
Opened.
hotel, Lordship.
Good.
Now, Lordship, on the second Lordship contest, Lordship, or renewal of my license, Lordship.
So you make an application,
Yes,
and
sir,
then take a decision.